All rise, veuillez vous lever. Please be seated. Veuillez vous asseoir.
Welcome back to everyone. We will now proceed to hear from OPCV. 15 minutes. You have the floor.
Thank you, Madam President. Before I start, based on our team's counting, the legal representative used 65 minutes. So my question is, if I need just a few minutes, more than 15 minutes, would it be possible for me just to use this time, not spent by my colleagues?
We would prefer very much that we stick to the allotted time. There could be some flexibility if necessary, but please try and finish within the 15. Thank you.
Thank you, Madam President. And I will make my submissions in French. Madame la Présidente, Madame et Monsieur les juges, pendant mon intervention, je vais aborder deux thèmes. Premièrement, pour des raisons de la publicité, je vais donner un résumé de mes soumissions écrites s'agissant des types et modalités de réparation que je propose pour les victimes dans cette affaire, avec quelques clarifications relatives à mes propositions. Deuxièmement, je vais aborder brièvement la question relative à l'éligibilité des bénéficiaires potentiels de réparation en tant que victimes directes des crimes autres que le crime de persécution pour lesquels M. Hassan a été reconnu coupable. S'agissant de mon premier thème, je représente quatre individus qui sont en premier lieu victimes du crime sous le chef d'accusation 6, qui est le crime qui porte sur condamnation prononcée et exécution effectuée sans un jugement préalable rendu par un tribunal régulièrement constitué. Ces victimes ont subi des préjudices profonds et multidimensionnels, à court et à long terme. Ceci inclut des souffrances physiques dues à la détention et, pour certaines, la punition corporelle. Un traumatisme psychologique marqué par l'humiliation, l'anxiété et une détresse émotionnelle durable, ainsi que le préjudice matériel, puisque les moyens de subsistance des victimes et leur stabilité familiale ont été perturbés, et puisque certaines de ces victimes ont dû abandonner leur lieu de résidence habituel. Aucune de ces victimes n'a jamais pu retrouver le niveau de vie qu'elle avait avant la commission des crimes qui les ont touchés. Les membres proches des familles de ces victimes ont subi des préjudices psychologiques, mais également le préjudice matériel, puisque plusieurs parmi eux étaient et sont encore et toujours dépendants financièrement des victimes directes. Donc les quatre victimes que je représente ont demandé que des réparations en leur faveur puissent inclure des mesures de soutien socio-économique, d'un côté un paiement financier pour aborder leurs besoins les plus urgents, ainsi que les besoins des membres proches de leur famille, et de l'autre du soutien pour entamer des activités génératrices du revenu, pour assurer leur bien-être et moyens de subsistance durables. Elle souhaite également que des mesures de réparation appropriées soient accordées pour rétablir, dans la mesure du possible, la structure sociale de la communauté de Tombouctou en tant que telle. Les éléments du dossier démontrent que les autres victimes directes et indirectes des crimes autres que le crime de persécution ont subi des préjudices semblables, tels que décrits ci-dessus. Les victimes du crime de persécution ont subi un traumatisme collectif du seul fait de leur appartenance religieuse, mais également puisque les structures sociales, religieuses, éducatives et autres de la communauté de Tombouctou ont été affectées de façon significative par les crimes pour lesquels M. Hassan a été reconnu coupable. Le préjudice va au-delà des individus, mais s'étend à la communauté de Tombouctou en tant que telle. La communauté de Tombouctou a subi des préjudices multidimensionnels tels que préjudice communautaire, économique, ainsi que le préjudice transgénérationnel qui est celui qui affecte les générations à venir. Compte tenu des multiples préjudices subis par les victimes et conformément aux souhaits des victimes que je représente, je propose les types et modalités de réparation suivants à être accordés aux victimes dans la présente affaire. Premièrement, je propose une compensation symbolique de montant standard de 600 000 francs ouest africains à être accordée à chaque victime directe des crimes autres que le crime de persécution. Cette compensation permettra d'aborder les besoins les plus urgents des victimes concernées, mais elle est également censée porter ses fruits aux membres proches de familles des victimes directes. Ce montant de compensation a été calculé eu égard à la pratique de la Cour dans les autres affaires, mais également en tenant compte des principes de l'établissement des montants de compensation envisagés par la politique nationale de réparation au Mali. J'insiste que la compensation proposée doit être considérée comme symbolique et doit être complémentée par des mesures de réparation additionnelles. Deuxièmement, je propose des réparations collectives avec des composants individualisés sous forme de mesures de réhabilitation médicale, psychologique et socio-économique à être accordées à toutes les victimes directes et indirectes des crimes autres que les crimes de persécution. Cette proposition est inspirée par la pratique de la Cour dans les affaires Lubanga et Ntaganda. Ces mesures de réparation devraient inclure un soutien socio-économique pour permettre aux victimes d'entamer des activités génératrices du revenu selon les préférences des victimes. Troisièmement, je propose des réparations collectives à base communautaire à être accordées à la communauté de Tombouctou en tant que telle et aux membres de la population de Tombouctou, incluant les victimes du crime de persécution. Cette proposition est inspirée par la pratique récente de la Cour dans l'affaire Ongouben, selon laquelle cette réparation devrait inclure des mesures de réhabilitation collective. Dans les circonstances particulières de la présente affaire, je propose que des réparations collectives à base communautaire devraient inclure deux volets. Le premier volet sont des mesures de réhabilitation communautaire afin de restaurer, dans la mesure du possible, les structures sociales, religieuses, éducatives et autres de la communauté de Tombouctou. Le deuxième volet sont des mesures de réhabilitation qui devraient viser collectivement des groupes larges de la population. D'un côté, des mesures de réhabilitation psychologique sous forme, par exemple, d'une thérapie psychologique collective. D'autre côté, des mesures de réhabilitation socio-économique qui devraient permettre aux groupes larges de la population d'exercer collectivement des activités génératrices du revenu. Une option pourrait être, par exemple, des associations ou bien des coopératives d'agriculture. Le Fonds Profil Victimes, qui a l'expertise et l'expérience de travailler surtout au Mali, pourrait peut-être proposer plusieurs projets d'activités qui serait en mesure d'associer des groupes larges de la population. Cette forme de réhabilitation pourrait inclure également, par exemple, des formations professionnelles. Et bien entendu, qu'aucune des mesures de réhabilitation collective ne saurait être imposée à des membres de la population qui ne souhaiteraient pas en bénéficier. Donc la participation des victimes au projet proposé devra être entièrement volontaire. Quatrièmement, je propose des mesures symboliques ou bien des mesures de satisfaction. Mais de telles mesures ne devraient être conçues qu'en consultation avec les groupes plus larges des victimes, ainsi qu'avec des chefs et notables de la communauté. S'agissant de la possibilité d'expression des excuses par M. Hassan, je ferai quelques observations additionnelles pendant la session questions-réponses. Je pourrais tout de même d'ores et déjà proposer une mesure symbolique avec un effet pratique suggéré par certains de mes clients et qui rentre dans l'objectif de restaurer la cohésion sociale. Il s'agit de la construction d'une ou de plusieurs salles polyvalentes, ou bien salles de réunion, qui pourraient rassembler des groupes larges de la population pour, par exemple, suivre des séances de la thérapie collective, ou bien de la formation professionnelle, ou pour discuter des questions de l'intérêt commun. Je voudrais souligner que les mesures de réparation à être accordées aux victimes dans la présente affaire devraient être discrètes, inclusives et adaptées aux réalités vécues par les personnes concernées, ainsi qu'en tenant dûment compte de la situation sécuritaire dans le pays en général et dans la communauté de Tombouctou en particulier. La mise en œuvre de ces mesures ne doit en aucun cas donner lieu à la stigmatisation des bénéficiaires, ni aux tensions ou jalousies au sein des communautés respectives. J'aborderai certaines questions additionnelles pendant la session questions-réponses. Je passe maintenant à mon deuxième thème. Dans l'une de ces émissions écrites, la défense de M. Hassan argumentait que seulement les victimes spécifiquement citées dans le jugement devraient être considérées pour des besoins de la réparation comme victimes directes des crimes autres que le crime de persécution. Et que le fait de reconnaître pour des besoins de la réparation le statut de victime directe aux autres personnes porterait préjudice à la présomption d'innocence de M. Hassan. Je soumets respectueusement que le nombre des victimes directes des crimes concernés et pour des besoins de la réparation de cette affaire ne devra pas être limité aux victimes spécifiquement citées dans le jugement. Et cela pour des raisons suivantes. Dans la présente affaire, probablement pour des raisons stratégiques, l'accusation a avancé dans le cadre de la présentation de sa cause un certain nombre d'incidents impliquant les victimes, afin de démontrer la responsabilité pénale de M. Hassan pour les crimes autres que les crimes de persécution. La Chambre a reconnu la responsabilité pénale de M. Hassan pour les crimes concernés sur la base de la preuve présentée et notamment eu égard aux incidents avancés par l'accusation. En ce faisant, la Chambre a également déterminé le statut de victime des individus cités par l'accusation sur la base du standard de la preuve au-delà de tout doute raisonnable. Je rappelle que l'article 75 du statut de Rome énonce explicitement le droit des victimes aux réparations pour le préjudice leur causé par les crimes pour lesquels l'accusé a été reconnu coupable. Le standard de la preuve applicable pour la détermination de l'éligibilité des victimes pour réparation est la prépondérance des probabilités, qui est beaucoup moins élevé que le standard de la preuve au-delà de tout doute raisonnable. Selon ce standard de la preuve, il ne requiert que de démontrer qu'il est plus probable que non que les personnes concernées a subi préjudice causé par l'un des crimes pour lesquels l'accusé était reconnu coupable. Selon la pratique de la Cour, au cas où la victime n'est pas en mesure d'apporter de preuves documentaires ou autres pendant la procédure de réparation, une déclaration cohérente de cette personne pourrait suffire pour qu'elle puisse être qualifiée pour réparation. Si la thèse avancée par la défense devait être suivie, cela signifierait, premièrement, que le droit des victimes à la réparation, leur énoncé par le statut de Rome, devrait dépendre entièrement de la discrétion ou bien du choix stratégique de l'accusation, d'avancer ou pas dans le cadre de la présentation de sa cause certains incidents impliquant les victimes et de ne pas avancer les autres, ainsi que de son choix stratégique de citer ou pas nommément certaines victimes. Deuxièmement, cela signifierait que l'éligibilité des victimes pour réparation devrait être déterminée dans le cadre du jugement et selon le standard de la preuve le plus élevé, qui est le standard au-delà de tout doute raisonnable. Je soumets respectueusement que cette approche est tout simplement irréconciliable avec la nature même du système de la réparation devant cette Cour, qui prévoit que l'éligibilité des victimes pour réparation doit être déterminée en vertu du standard de la preuve, qui est la prépondérance des probabilités. La thèse de la défense apparaît encore plus dénuée de tout fondement à la lumière des considérations de la Chambre, contenues dans le jugement relatif au mode de responsabilité pénale de M. Hassan pour la commission des crimes en question. La Chambre a déterminé, au-delà de tout doute raisonnable, le mode de responsabilité pénale de M. Hassan pour les crimes concernés en vertu de l'article 25.3d. Il s'agit du mode de responsabilité sous forme d'une contribution par toute autre manière. Ce type de contribution ne requiert pas de démontrer un niveau ou une manière spécifique de la contribution, contrairement aux exigences contenues, par exemple, au paragraphe A, B et C de cet article. La Chambre a développé en détail la façon de la contribution de M. Hassan pour la commission des crimes en question, eu égard aux éléments suivants. Premièrement, la police islamique a joué un rôle crucial pour assurer la mise en œuvre du système de répression et de punition tel qu'instauré par le groupe Ansar Din Hakim à travers toute la communauté de Tombouctou pendant la période entre avril 2012 et fin janvier 2013. Deuxièmement, M. Hassan n'a pas occupé une position secondaire, mais au contraire a joué un rôle crucial et important au sein de la police islamique et au sein du groupe Ansar Din Hakim en général. M. Hassan était l'un des leaders de la police islamique. Il avait un rôle important dans la mise en œuvre du système de répression établi par le groupe Ansar Din Hakim, par lequel des membres des institutions différentes ont commis les crimes. Je comprends que j'ai dépassé déjà le...
Oui.
Ouais. Est-ce que je peux avoir 2 minutes pour conclure?
2 minutes seulement.
Ok, parfait. Merci, Madame la
Merci.
Présidente. Donc, je ne vais pas citer les autres exemples puisqu'ils sont dans le jugement et aussi dans le jugement sur la peine. Donc, à la lumière de considérations de la Chambre contenues au jugement de la peine, il est pareil que les mesures de répression de punition ont été mises en œuvre à l'échelle élargie systématique à travers la communauté de Tombouctou pendant une période étendue qui est de 9 mois. Selon les estimations fournies par le Fonds de profit de victimes, plus de 1210 personnes ont été condamnées sans jugement prononcé par un tribunal régulièrement. Plus de 7500 personnes ont été détenues et plus de 9000 ont subi des punitions corporelles. En conséquence, en vertu du standard de la preuve qui est applicable à ce stade et qui est la prépondérance des probabilités, il est plus probable que non, qu'un nombre beaucoup plus élevé des victimes que celles citées dans le jugement ont subi directement des préjudices causés par les crimes autres que les crimes de persécution, et donc leur éligibilité pour réparation devra être évaluée en vertu du standard applicable à ce stade et conformément aux critères d'éligibilité qui devraient être établis par la Chambre. Pour conclure, s'agissant de l'argument de la défense que le nom plus important, la reconnaissance d'un nom plus important des victimes directes des crimes autres que persécution à ce stade-là pourrait porter préjudice à M. Hassan, je rappelle que la responsabilité pénale de M. Hassan a été déjà déterminée de façon définitive, la peine a été fixée de façon définitive et la réparation devant cette Cour n'a aucun effet punitif pour les personnes reconnues coupables. Le seul objectif de cette procédure, c'est de permettre aux victimes d'obtenir des réparations dans la mesure du possible pour le préjudice qu'ils ont subi. Donc, en conclusion, je demande respectueusement à la Chambre d'écarter cette approche de la défense et puisque si cette approche est suivie dans cette affaire, cela pourrait constituer un précédent extrêmement dangereux pour l'avenir, avec des effets néfastes pour tout le système de la réparation devant cette Cour. Je vous remercie.
Merci beaucoup. Maintenant, Monsieur Duterte, pour la procureure.
Je vous remercie, Madame la Présidente. Si je peux me permettre, je vais essayer de récupérer le pupitre de mon excellent confrère. Merci Madame la Présidente, merci Madame la Juge, merci Monsieur le Juge. J'essaierai de tenir le temps qui m'est imparti et de rester plutôt autour de 10 minutes qu'un quart d'heure. Il n'est pas coutume que l'accusation soit souvent impliquée dans la phase de réparation de la CPI. Et la Chambre de première instance 2 a jugé dans l'affaire Ntaganda que l'accusation n'est pas une partie dans la phase de réparation. Cela concerne en effet au premier chef les victimes. Et aussi bien l'accusation remercie la Chambre d'avoir eu l'obligeance de la convier aujourd'hui à la présente audience. Permettez-moi de faire le focus, d'insister sur quelques points simplement. À commencer par les femmes et les jeunes filles de Tombouctou, dont le courage lors de la manifestation d'octobre 2012 n'est plus à démontrer et force le respect. Monsieur Hassan, ici présent, a été reconnu coupable d'avoir directement participé à la mise en œuvre de la politique de persécution diligentée par Ansardine et Acme et d'avoir contribué quotidiennement à la campagne menée par Ansardine et Acme visant la population civile pour des raisons religieuses. Et je ne vais pas répéter la liste que mon collègue précédent avait commencé à énumérer. Et force est de constater que les femmes et les jeunes filles ont particulièrement été touchées par cette persécution religieuse. Dans le jugement de condamnation, la Chambre a relevé au paragraphe 1570, je cite en anglais, specific rules and prohibitions imposed on women and their enforcement had a significant impact on all aspects of the life of women in Timbuktu. In fact, women feared going outside, drastically reducing their activities outside of the home. End of quote. De manière similaire, dans le jugement sur la peine au paragraphe 74, la Chambre a également pris soin de préciser, et je cite à nouveau en anglais, ouvrez les guillemets, the restrictions imposed, notably on the appropriate clothing and the occupation of the public space, were implemented in such a way that they had a specific and disproportionate impact on females, members of the population of Timbuktu, who, in the circumstances, were in a position of particular vulnerability. End of quote. L'accusation note aussi la composante genrée du préjudice découlant pour les femmes d'autres crimes ou des circonstances sous-jacentes à d'autres crimes pour lesquels M. Hassan a été condamné. Je fais par exemple allusion au cas de flagellation pour adultère ou entre autres à un certain nombre de décisions ou mesures prononcées en matière maritale, comme par exemple pour une supposée insubordination. Et je dois dire que l'impact de la persécution d'Ansardine et d'Acmi pour des raisons religieuses sur les femmes n'est pas une coïncidence. Quand on cherche à dominer une population, à l'assujettir, un moyen classique est de s'en prendre aux femmes, ce qui a moyen de toucher par ricochet les hommes et la société entière. Et permettez-moi de rappeler juste un élément de preuve pour illustrer cela. Dans la vidéo MLI OTP-0011-0376, aux lignes 97 à 100 du transcript correspondant, un Tombouctien disait dans les termes suivants, je cite, « On n'avait plus de dignité. Nos dignités sont vendues parce que quand on frappe ta femme devant toi, on frappe ta sœur devant toi, tu peux rien dire, on frappe ta propre maman devant toi, tu ne peux pas parler, c'est que tu n'as plus de dignité. » Au total et en tout état de cause, l'accusation soumet que la Chambre doit adopter une approche inclusive en matière de genre et promouvoir une parité de genre dans tous les aspects de la réparation. Et j'imagine que la défense ne voit pas d'obstacle à une telle approche. Et car en réparant le dommage subi par les femmes, en leur restituant en partie leur dignité, on restitue en partie la dignité de toute la population. Ce mot de dignité, je l'ai entendu dans la bouche de Maître Doumbia. Et au-delà des aspects pécuniaires, matériels, cette dimension morale a toute sa valeur. Je passe À mon deuxième point, Madame la Présidente, Madame, Messieurs les juges, c'est la question du nombre de victimes. Et la Chambre a jugé dans le jugement sur la peine au paragraphe 74 je cite en anglais, On Sardine and Acme targeted not only members of the population who opposed them, but also every member of the population who saw themselves forced to abide by rules and prohibition. Je passe quelques mots et je continue. The number of victims of a crime of persecution is therefore very high. The entire population of the city of Timbuktu was targeted and was the subject of a deprivation of fundamental rights. Et à cet égard, l'accusation souhaite souligner que il faut aussi prendre en compte les membres de la population qui ont fui Tombouctou pour échapper à la persécution religieuse menée par Ansardine et Acme. Car toutes ces personnes ont subi un préjudice matériel et moral en quittant la ville, évidemment. Et un témoin, vous pouvez le lire dans nos écritures, a estimé à 30% de la population de Tombouctou le nombre de personnes, d'habitants qui ont fui la ville. Le troisième point que l'accusation souhaite soulever est l'âge des victimes, conformément à l'article 68, de même que le préjudice lié à l'âge des victimes et leurs besoins, conformément à la règle 86. Je pense à telle personne âgée, victime d'un membre d'Ansardine et d'Acme. Je pense aussi par exemple à P-0565, qui avait environ 14 ans lorsqu'elle a reçu 100 coups de fouet à Tombouctou en 2012, devant une foule réunie. De sorte que, dans son programme de réparation, votre Chambre devrait notamment prendre en compte les besoins particuliers des victimes qui étaient enfants à l'époque des crimes, en gardant à l'esprit tout effet à long terme que ces crimes ont pu avoir sur leur développement. La réparation pour les victimes mineures doit ainsi en particulier couvrir les pertes de chance pour le futur qu'ils ont pu subir. Et les réparations devraient aussi comprendre des mesures pour prévenir l'ostracisme et la discrimination contre les enfants, de même que promouvoir leur réintégration dans la société. Deux derniers points rapidement, Madame la Présidente, Madame, Monsieur le Juge. C'est la définition du concept de préjudice qui doit être interprété de façon large. Le préjudice peut être matériel, physique ou moral. Il ne doit pas nécessairement être direct. Il peut y avoir des victimes indirectes pour autant que le préjudice leur soit personnel. Point 2. Dans ce contexte, il convient de souligner que le genre de crimes pour lesquels M. Hassan a été condamné a des effets parfois transgénérationnels, et je fais écho à ce que notre confrère de l'Office public des victimes a développé précédemment. Les traces de coups de fouet ne disparaissent pas sur un père ou une mère. Les enfants, les petits-enfants les voient. Ils ne peuvent pas faire comme s'ils ne les voyaient pas. Il faut tenir compte de ce facteur qui est très important. Et tout programme de la Chambre devra le fracturer, nous le soumettons. dernier point, et je me permets d'insister, en dehors des personnes physiques, il y a également des entités qui ont été impactées par le crime de persécution. Je pense aux écoles qui ont été fermées ou forcées d'appliquer les vues religieuses dans Sardine et d'Acmi. Un témoin a pu évoquer le chiffre de 150 écoles fermées qui ne pouvaient pas mettre en place les conditions imposées par ces groupes. Et là également, il y a des effets à long terme, naturellement, notamment sur l'éducation des enfants qui ont été touchés. Pour finir, Madame la Présidente, Madame, Monsieur le Juge, la réparation dans l'affaire Almadi est bientôt achevée. Grâce à l'action conjuguée de la Chambre concernée et notamment des LRV et du Trust Fund. Le chantier s'ouvre maintenant dans l'affaire Hassan et l'expérience accumulée notamment par les représentants légaux des victimes ou le Trust Fund qui ont l'habitude du terrain, de la réalité de Tombouctou et des questions de sécurité. J'insiste beaucoup là-dessus et je ne vais pas aller dans le détail, mais elles sont majeures, sera sans doute très précieuse à votre Chambre. Je vous remercie.
Merci beaucoup, Monsieur Duterte. And now we will hear from the Trust Fund for Victims. 30 minutes, please. Can you try again, please? Can you? Perhaps you could use the row behind if it's working while we try and deal with the technical problem. Yeah, thank you very much, Ms. Ruiz Ventusa.
Thank you. Good morning.
Good morning. Please proceed.
Your Honors, I would like to first place on the record that our team composition at the Trust Fund for Victims has changed over the break. I am now present in the room. My name is Deborah Ruiz Verduzco. I'm the Executive Director, and my colleague, Veena Suresh, Associate Legal Officer, has also joined the team. The Trust Fund is honored by the opportunity of addressing the Chamber at this critical stage in the proceedings to deliver a set of observations by the TFV which complement our written submission. In these oral observations, I will cover 3 issues: the question of the Chambers in relation to costs, a matter in relation to the principles of reparations, and other issues related to the implementation of an eventual reparation program. In relation to costs, in addressing this topic, the Trust Fund needs to be reminded of the current stage at which the proceedings are. This is the judicial reparation stage that will result in the issuance of a reparation order. This stage needs to look at both what has been destroyed by the crimes committed for which Mr. Al-Hassan was convicted for, as well as what has to be repaired. And when looking into addressing the matter of costs, we are naturally brought often into a bargaining process, because we are, of course, naturally compelled, the Trust Fund, and possibly you as well, on the tension between the principle of what it is and the reality of what can be. There needs a need to balance full recognition with feasibility. However, for this approach, the Trust Fund respectfully posits that if we are reminded at the moment at which we are, there is no need to engage in this bargaining. Today and in the current phase, the reparation order should recognize the harm suffered by the victims and consider the liability of the convicted person in relation to those victims. In the future, once the order is issued, in the next phase, the administrative implementation will begin, and practical considerations can inform better future decisions. Now, going into the matter of costs. Of course, drawing an estimate needs to be grounded on several assumptions for issues that are yet to be determined, both in the order and during implementation. That is, the judges have to determine the extent of the harm, the measures ordered, and the criteria and final or estimate number of eligible victims. In addition, certain costs might be further impacted by individual and specialized assessments of the victims' conditions themselves. For instance, medical assessments, treatment plans that will determine the scope of a medical intervention, and that will, of course, also result in potentially different costs. But to move into this exercise in a productive and helpful way to the stage at which we are, we have ensured that we use certain assumptions and we make those assumptions explicit, therefore allowing the chambers to adjust our calculations to the extent that you finalize certain matters, especially when our assumptions might drastically change. As I will present the cost, my statements reflect summative amounts. Should the trial chamber require so, the detailed calculations that have led to these sums can be made available in writing. The key assumptions are that from the information that the Trust Fund obtained from relevant stakeholders, as well as through an ample study of victims' views that we have called the 2025 Victims' Voices Study, harm has been suffered by the community, by specific groups within the community affected particularly, and by a number of individuals in particular within that community. In relation to cost, therefore, we will address first the cost covering measures for the community, which is a category of victims in its own right. All parties have recognized that the crime of persecution has affected the entire population, collectively and communally. The Chamber itself has recognized this in its judgment decision of 26 June 2024. The harms may be considered to be moral, psychological, religious, and economic. The TFV collected information on some measures proposed by the members of the community, and these notions have informed the way we have gone about cost estimations. In relation to community, symbolic commemoration, and satisfaction measures, the community has given us some ideas. These include the inscription of the Moalid on the national and world heritage lists, memorialization initiatives, and educational programs. The cost estimate for these measures is around 1.1 million euros. This calculation comprises 6 symbolic measures, valued each between 90,000 euros and 200,000 euros. For socioeconomic rehabilitation measures, the Trust Fund is informed by a community-based approach followed in the Almaty program, which comprises the selection, accompanying, and funding of micro and macroeconomic projects. Those projects are estimated between 300,000 euros each and 30,000 euros each for the micro ones. If we estimate that 4 macro projects can be implemented and 80 micro projects can be delivered, also focusing on particular communities affected, such as Christian minorities, certain professions that were prohibited or restricted during the occupation, or individuals who saw their fundamental freedoms violated or were forced to flee Timbuktu, then we can estimate that the socioeconomic measures at the community level could be valued at around 4 million euros. Finally, concerning the need of psychological rehabilitation, the Trust Fund recognizes that interventions are required across the community. In the Almaty program, the Trust Fund has implemented community-level psychosocial interventions. If we estimate to reach around 10,300 individuals, the cost of these measures would be 1.2 million euros. Together, all these community measures are estimated at around 6.3 million euros. These costs include costs that have been included and detailed as cost C in our written submission. Now, at the individual level, Your Honors, of course, the harm was suffered by individuals themselves. And the question is, how many individuals have suffered this harm? In our study, we understand that more than 9,000 individuals, 9,453 precisely, suffered severely, 8,849 moderately, and 9,563 mildly. There are also other similar numbers for severe economically affected, moderately affected, and mildly affected individuals at the individual level. If individual medical or psychological measures are implemented, the Trust Fund estimates that basic care will cost 150 euros at the minimum, up to 6,000 euros for major care. If you want to make the calculation, the numbers that are provided in the victim study by unit cost will allow to obtain a total amount. However, from a general calculation made by the Trust Fund, we estimate that only 10% of those affected severely have actually acute persistent harm. So that would be another approach for the Chamber to consider individualized measures. In relation to socioeconomic measures, the Trust Fund makes reference to programs implemented elsewhere where individuals receive between 350 euros and 850 euros in addition to training. With this cost in mind, the variation of individualized measures ranges from 21.3 million if the entire population of affected individuals is considered, or 3.9 million if only those affected severely with acute persistent harm are considered. That is 10% of the total population. Finally, in relation to compensation and individual awards, this is a matter that the Trust Fund did not address in its written submission. This can be, of course, awarded through individual or through collective awards as a modality of reparations. The Trust Fund has taken note of the submission of the parties, the amici curiae, and the prosecutor in relation to compensation or individual measures. There is a clear preference in their submissions for that compensation, for example, in the form of symbolic payments. The Trust Fund took note of today's submissions of the LRV to provide 350 euros to each victim, and of OPCV LRB proposed to get an orientation for such symbolic payments from the Malian National Policy on Reparations. In this regard, the TFV recalls that such policy provides for a comprehensive compensation scale for physical, psychological, and material damage, that a dedicated agency, the AGRV, has been created and is in the process of being operationalized. The amounts for compensation in this policy ranges from 900 euros to 5,500 euros for physical and psychological rehabilitation, and up to 7,300 euros for economic rehabilitation. These amounts would need to be extrapolated to the number of the victims the Chamber considers eligible. The Trust Fund, however, submits respectfully that in order to impose a compensation scheme as a modality for reparations, prior cases of trial chambers that have established prerequisites for compensation, including individualized assessment of harm, might be required. It is also important to consider that the application of the Malian National Policy on Reparations fall exclusively within the competence of the Malian authorities, and we caution the way that referencing or relying on this law may be relevant for purpose of estimates relevant to the application in the ICC. From a practical perspective, should victims receive compensation through the ICC, Malian authorities may request the court to share information on those individuals to ensure no double reparation. And measures would need to be put in place to facilitate or articulated and refined these principles across several cases. They represent an evolving body of law and practice that reflect legal thought and on-the-ground experience. These principles are not only our guiding standards, but they are also the benchmarks at which we measure our outcomes and we evaluate the success of implementation. They have been integrated into every activity we undertake, and we seek to pursue that the Chamber advances these principles on this occasion. And we respectfully submit 3 recommendations for the refinement of reparations principles. The first one, similar to the Ntaganda principle that implementation must be gender sensitive and inclusive, the Trust Fund proposes that it should also be conflict sensitive. Reparations should be designed with an awareness of prevailing tensions so as to not exacerbate them, but instead to ensure that they contribute to rebuilding trust and fostering coexistence. Secondly, participatory reparations. It is necessary that the principles go beyond the principle of consultation, a victim-centered approach, or accessibility. Instead, we believe that participatory approaches ensures that victims participate in the design, in the evaluation, and in the consultation of the way that reparations are implemented. Finally, the principle of adaptive prioritization. This is set out in paragraph 129 of our written observations that refers to the necessity of enabling and empowering the implementation phase to adapt to practical limitations as well as to preference of communities. This issue of principles leads me now to address the issues of implementation that we may face in the future. In this regard, I wish to make simply brief reference to important factors that are essential looking forward, but that are not necessarily pertinent at this point for the reparation order. The first one is the essential element of the order to be well known and understood by the communities, while also measures specifically addressed to individual victims be accompanied by confidentiality and other manners to protect the victims themselves. We will be certainly informed by the security context, which in the Almaty case has defined the way we adapt to manage tensions, access, and ensure access conditions, but that the security context has very much been informed by the level of cooperation that we have received from the Malian authorities themselves. Mali, as a state party that has also welcomed the physical presence of the court in its territory, has cooperated with the Trust Fund in the implementation of the reparations at the national level as well as at the local level, including through a steering committee that was established to oversee the implementation of these reparations. This brings me, of course, to the essentiality of the cooperation of Mali to the success of the reparations and of the order. The Trust Fund values the constructive engagement it has received, and we posit, Your Honors, that it could also be the Malian state could be encouraged to continue this cooperation. It is important to acknowledge the progress in relation to transitional justice that the Malian law provides, and the necessity for any future program of reparations to be implemented in a manner that strengthens the trust that individuals have on the Malian state, and that ensures that that implementation of the policy is catalyzed and further expanded. As a final point, Your Honors, I would like to emphasize as well that the Trust Fund would welcome any contribution that Mr. Al-Hassan could make economically, however modest, to meet his financial obligations under the reparation order. The evaluations that we have conducted on reparation programs show that any gesture by the convicted person, even a symbolic one, can have a significant effect on the value of any measure that the court may issue. For the victims to accept some gesture may take some time. And as researchers of the University of Edinburgh indicated in their amicus curiae, it often has a multiplier effect on the victim's satisfactions. Combined with a sincere and excessive apology, such a financial contribution has the potential of being deeply reparative. The Trust Fund anticipates the finalization of this phase of the proceedings. We remain prepared and ensuring our increased readiness to implement any program and any decision that you may deliver, as it will be certainly for the benefit of the court's legitimacy, of the victims, and of the trust in institutions that these measures can take. Thank you, Your Honors.
Thank you very much for those submissions. We will move now to the defense. Ms. Taylor, in the interest of efficiency and time, we have obtained the registry's cooperation to extend the session to 1:15 in the hope that the defense can complete their submissions. But if, appreciating you have 45 minutes, if there is any remaining remarks you wish to make after that, we can take a few minutes in the next session. That will leave us good time for a back and forth with the parties and participants in the final session. So if that's acceptable to you, we'll begin your submissions and we'll see how we proceed. Thank you. Ms. Taylor, you have the floor. I'm sorry, Ms. Taylor, we seem to have the same problem. It seems to be a front row problem today. Can we test? Can we test the middle section there with the front row? Don't seem to have anything. Can we try the second row there to see if that is working?
Test.
Perhaps, Council, you could just check and see if your microphone is working?
Hello? That works?
Yes.
Okay.
Yes, sorry, Ms. Taylor, we'll have to have the same adjustments to position.
Are you okay to do the same? I'll get my...
Please proceed, Ms. Taylor.
Is this working now? Thank you. I will be addressing the role of Mr. Al-Hassan in this process, and also the issue of how the victims are identified and defined in connection with Mr. Al-Hassan's conviction of persecution. My colleague, Maître Berlulissier, will focus on proposed modalities to ensure a fair and efficient and non-discriminatory process. The defense has filed a table of authorities, and we will be referring to these authorities by number. We are also showing a document on the screen. It should be broadcast in public. While Mr. Al-Hassan is indigent, he would like to underscore his wish to contribute to this process to the best of his ability and in a way that is impactful. And there are 4 different ways by which he is seeking to repair the harm caused by his actions. The first is his public apologies. The second, through the assistance he provided voluntarily in identifying victims. The third concerns a financial contribution to the trust fund. And the fourth relates to his support for an efficient and effective reparations process which will be addressed by Maître Beaulieu-Lucier. Mr. Alassane issued 2 public voluntary apologies. The first on 17th of December 2024, and the second on 14th of April 2025. And they have both been widely disseminated in local languages. The April apology can now be seen in French on the screen. His apology was not intended to reduce his liability for reparations, and we're not asking that it do so. For some victims, it may be a form of satisfaction, for others it will not. Grief and suffering are personal, and they manifest differently for everyone. And that is why he ended his apology by emphasizing that the victims of Timbuktu have the right to both seek justice through the International Criminal Court's reparations process and to choose whether to accept my personal apology. These are not choices that need to be made against each other. If I may ask, is the document being shown?
Find it, Ms. Taylor.
Evidence Channel 1.
Thank you. I have a picture on Evidence Channel 1. I would suggest we continue, Ms. Taylor, and there seems to be a technical problem. Hopefully it can be resolved. Thank you.
Certainly. Certainly. The complexity of the events and the diversity of experiences in Timbuktu calls for a multi-pronged approach to reparations that accommodates diversity and difference. And we suggest that there's room within such a strategy to use Mr. Alassane's apologies to help repair the harm he caused and to prevent its recurrence. And we further propose that his apology may resonate with the following groups of persons. The first are the victims. The second are the other individuals who made wrong choices and whom he may now be able to influence in a positive manner. The third is the community of Timbuktu, whom he seeks to support the reparations process. As concerns the victims, Mr. Alassane has used a particular supplication which is derived from the Sayyid al-Istighfar. And he chose this language because the Prophet has decreed that it is the most powerful and genuine apology that a Muslim can use. And there are 3 key reasons why that is the case. First, it is anchored in faith. And that means to invoke it, you have to be truly repentant because you can't lie or pretend to God. As Mr. Alassane said in his sentencing statement, God sees into his heart and will know if his apology is from his heart or not. That's reference 2. Second, the supplication uses languages which juxtaposes the blessings received from God and the fact that the person has sinned. This shows that the person acknowledges their wrongdoing and shows repentance for having disappointed God. And third, the reference to keeping God's covenant is a pledge to God to never repeat the wrongdoing. And I refer to reference 3. So when Mr. Alassane apologized to all the victims he harmed, he made this apology from his heart, and he used the Sayyid al-Istighfar to emphasize his pledge before God to repair and never repeat this conduct. This is an apology built on Mr. Alassane's religious faith, but it is also addressed to all victims, irrespective of their faith. And that is why Mr. Alassane cited the Prophet's statement that not one of you truly believes until you wish for others that which you wish for yourself. This statement is an iteration of the principle of mutual respect for other people, other values, and other religions. Mr. Alassan's religion is important to him, but he also understands that in the same way his beliefs are important to him, other people may have different beliefs which are equally important to them and equally deserving of respect and protection. And that's why he acknowledged in his public apology that it was wrong for the groups to impose foreign beliefs and ideology on the people of Timbuktu in 2012, and it was wrong for him to have been part of that. This public acknowledgement of wrongdoing and pledge before God of non-repetition are elements of the right to a holistic remedy. And since the community of Timbuktu has suffered from collective harm, it is significant that notable religious and community leaders have expressed their support for Mr. Alassan's apology. And they have further suggested that it can play a positive role in local reconciliation processes. And I refer to the statements at authority number 4. This brings me to the second potential group whom Mr. Alassan hoped to address with his apology. Mr. Alassan shared his path towards recognizing the suffering experienced by victims in the hope that it is a journey that resonates with others and encourages them to embark on similar paths. And in so doing, he talked about what he suffered not to minimize or excuse the harm he caused, but to highlight the importance of looking beyond one's own pain and opening your eyes to the perspectives and suffering of others. And he hoped to demonstrate that if someone like him can reach this understanding, others can do so as well. When Mr. Alassan came to the ICC, he had suffered from torture. He then lost a daughter. He was alone, afraid, closed off, and his religion saved him in his darkest time. And then the day of the conviction came, and the presiding judge clarified that this trial had nothing to do with either Sharia law or the Muslim religion in general. Reference 5. The war crimes and crimes against humanity were not committed by Islam, nor were these crimes the necessary and foreseeable byproduct of Islam. They were the product of specific individuals and specific policies developed by individuals and applied by force. The victims were targeted because of their religious views, but they were targeted by individuals and not by Islam. And because Islam is a religion that values peace and reconciliation among peoples, that embraces justice and kindness, it was right for Mr. Alassan to acknowledge his wrongdoing and seek forgiveness for the victims' suffering. And it's also the right thing for Muslims like him to state their opposition to acts that are not part of Islam, such as rape, forced marriage, or prohibition of work or education for women. And I refer to reference 6. And Mr. Alassan hopes through his public declaration that others will also see that it's not too late to say sorry, that it's not too late to recognize and repair this harm, with a view to ensuring that all communities and all faiths in Timbuktu can live together in social cohesion, de vivre ensemble. And this brings me to the third group that Mr. Alassan hoped would hear his apology, and that is the community of Timbuktu. Mr. Alassan was found by this chamber to have been generally well liked by the population of Timbuktu. That's reference 7. He has now called on that population to support the reparations process. He's also asked them to support victims' right to access justice, irrespective as to whether they accept his apology or not. And Mr. Alassan made this public statement to eliminate any potential stigma concerning the reparations process, or any perception that persons who viewed him favourably should not support this process or victims' rights. I'm turning now to Mr. Alassane second contribution to the reparations process, which is that he voluntarily shared information for the purpose of helping the registry locate and identify victims. And this information has now helped locate 6 previously unidentified victims, 2 of which are survivors. This in turn facilitated their right to access justice and the reparations process. And we respectfully submit that it's appropriate for the Chamber to refer to this voluntary assistance in the reparations order to highlight the importance of the right to truth and access to justice as core components of an holistic reparations process. The right to the truth and the related right to know the identity and location of victims are referred to as a form of satisfaction in the UN Basic Principles and Guidelines on the Right to a Remedy. That's reference 8. And an example of the application of these principles in restorative justice contexts can be found in Colombia's Special Jurisdiction for Peace, where perpetrators can volunteer to repair the harm by providing information that can help locate or identify victims. That's reference 9. And Mr. Alassane's actions are consistent with these principles and precedents. The individuals were publicly named in the judgment. There were therefore no protective measures. 3 were known to the defence, and the defence only took steps to identify the others after VPRS first confirmed that it had been unable to do so. So these were individuals who had not yet been identified by the registry and who might never have been identified if not for the voluntary assistance of Mr. Alassane. And Mr. Alassane has also expressed his willingness to assist VPRS in whichever way they deem helpful in relation to any other of the named 49 victims who have not yet been located. That's reference 10. And we submit that referencing this voluntary contribution in the reparations order would be helpful because first, Mr. Alassane's direct assistance is a very concrete indication of his support for this process and for the right of victims to come forward. And this is another action that can help eliminate stigma and promote security for the process. And second, it may also encourage other defendants in other cases to consider making similar contributions in support of the right to the truth. This brings me to the third contribution, which is that Mr. Alassane wishes to make a financial contribution to the Trust Fund for Victims, notwithstanding his indigency. To that end, he has proposed to save and contribute 164,000 CFA from his personal funds at the detention unit to be used as the Chamber deems most appropriate. This is the equivalent of about 17 weeks' income for Mr. Alassane and can cover the cost of a cow or sheep or a symbolic financial amount for direct victims. And we sought the opinion of the Trust Fund as to whether it be more helpful to make an immediate voluntary contribution that is separate from the reparations order or one that is part satisfaction of the order. And the Trust Fund in turn indicated that if such funds are used against payment of the reparations order, and if approved, this would be the first time that this would happen in the history of court-ordered reparations at the ICC. As concerns the proposed allocation, Mr. Alassane suggested in our filing of 16th of July that his contribution could form part of a symbolic ceremony organised by the Trust Fund. For example, sheep could be distributed as food on the occasion of a festival such as Tabaski or Maulud, the Prophet's birthday. And the idea behind this was to show his support for the reparations process and to underscore the importance of respecting local beliefs concerning such festivals. And we're also aware that in previous cases, reparations orders have provided for symbolic amounts to be given to victims in recognition of the harm done and suffering caused. That's reference 13 and 14. We defer to the Chamber and Trust Fund as concerns how best to use such funds. I'm moving now to the more complex question concerning the number of direct victims, including for the crime of religious persecution. There seems to be general agreement that since the crime of persecution targeted the community of Timbuktu as such, the collective identity of Timbuktu suffered community harm which should be recognized and repaired. The defense also supports the position that community reparations should address intersectional forms of harm and prioritize vulnerable groups within that community. And we submit that the approach to independent trauma in the Tuganda Reparations Addendum provides a sound framework for recognizing and repairing harm caused by crimes which Mr. Alassane did not commit. And that's reference 15. In Ntaganda, the Chamber accepted expert evidence that past exposure to trauma can make victims more vulnerable to future suffering and can also aggravate the way they experience such suffering. So even though Mr. Lubanga was not responsible for pre-existing trauma caused by the armed conflict in the DRC, this pre-existing trauma was relevant to reparations because it informed or impacted the way the victims experienced the crimes committed by Lubanga. So in the case before you, Mr. Alassane was acquitted of all crimes concerning sexual and gender-based violence. Judge Akane further found that such crimes fell outside the common purpose, did not satisfy the chapeau elements of crimes against humanity, and also could not be considered as underlying acts of persecution. That's reference 16. Nonetheless, the fact that victims experienced sexual violence and gender-based crimes would have impacted the way they experience the collective harm of persecution. There is therefore a basis for prioritizing schemes to repair such harm in any collective reparation schemes for persecution without imputing criminal responsibility to Mr. Al-Hassan. The same can also be said for historically discriminated segments of the community. And the notion of community may also include future generations impacted by harm. Children who died in infancy, those who were never born, the miscarriages caused by psychological stress or a lack of access to appropriate care. These are the points of agreement. Where there is disagreement is the question as to whether the fact that Timbuktu community suffered harm means that each member of that community can be considered as a direct victim in their own right. And it is our position that since Judge Akane's opinion is a reference point for the parameters of persecution, the verdict means that not every individual can be considered as a direct victim of persecution, and not every victim of persecution can be considered to be the victim of Mr. Al-Hassan. And while the trial judgment section on persecution refers to a majority of Judge Prost and Judge Mdua, this majority became the minority because of Judge Mdua's full acquittal by operation of duress. And as explained by Judge Akane, her opinion ultimately defines the scope of the conviction for persecution. That's reference 17. And in her opinion, Judge Akane set out two core limiting features on the crime of persecution. The first arose from the connection element, and the second, Mr. Alassan's personal liability. In terms of the connection element, Judge Akane found that under the Rome Statute, it's necessary to have a connection between the deprivation of rights and a specific crime. And she further found that this connection was only satisfied with a sufficient degree of specificity and notice in connection with the criminal acts underpinning Mr. Alassan's convictions in counts 1 to 5 and 14. That's reference 18. In practical terms, this means that the fact that someone was present in Timbuktu in 2012 and suffered from a severe deprivation of rights is not enough to make them a victim of the crime of persecution. And Judge Akani further restricted Mr. Alassan's responsibility for persecution to Article 25(3)(d). And while this mode of liability is not relevant to the quantum of his liability to repair harm, it is relevant to the scope of his convictions. And this is because the trial chamber expressly found that Article 25(3)(d) penalises contributions to specific crimes. And I quote, Article 25(3)(d) does not result in a reciprocal imputation of the acts of the member of the group. That's reference 19. Consequently, even though the group targeted the population of Timbuktu as a whole, Mr. Alassan's convictions under Article 25(3)(d) were based on specific incidents to which he was found to have made a culpable contribution. Now, the LRV have relied on Ongwen to claim that it is impossible to determine the number of victims at the time of judgment. That might be true for a case like Ongwen, where the defendant was convicted as an indirect co-perpetrator and bore individual responsibility for large-scale attacks involving multiple victims based not only on his actions but the actions of the group at large. But that's not the situation with this case. The Chamber was able to identify and list the incidents and victims related to Mr. Alassan's culpable contributions, and they did so in the annex to the judgment. And this means that the same direct victims who are the victims of counts 1 to 5 and 14 also constitute the direct victims of the crime of persecution on religious grounds. The fact that the community of Timbuktu suffered collective harm also does not mean that its individual constituents obtain derivative, direct victim status. As explained in Katanga, collective reparations differ from individual reparations. The former confer on a group a benefit to which its individual members are not exclusively entitled, whereas in the case of the latter, the benefit belongs to each member of the group. It's reference 20. In the context of the current case, this means that if the victims are being repaired as a member of the community and not in their individual capacity, their participation in collective schemes will not extinguish their individual rights and their rights to be recognized as direct victims and to receive full reparations for such in future proceedings. Conversely, if the Chamber were to find that every member of Timbuktu community is in addition a direct victim, then this would result in a reparations order that includes direct victims who were expressly excluded from Mr. Alassan's conviction and sentence. And this is precisely the scenario that was addressed by the Appeals Chamber in the Lubanga Reparations Judgment of 3rd of March 2015 at paragraphs 212 to 2014. It's reference 21. And there, the Appeals Chamber explained that where a group of victims have suffered harm as a community, the reparations order should not be framed in such a way as to impute liability to the defendant for victims within this community who fall outside the scope of the conviction. In the context of this case, the trial chamber expressly recognized in the sentencing decision that Mr. Alassan's liability for persecution does not encompass victims of sexual violence or forced marriage, nor does it encompass crimes committed independently by Hezbollah. To describe such individuals as direct victims of Mr. Alassan would exceed the scope of his liability. Words matter. the words direct victims generate a public perception of guilt. And the settled case law of the ICC means that these words cannot be used in connection with the very crimes for which Mr. Alassane was acquitted. And we know and appreciate that this is not the outcome that's been suggested to you today. But this situation is not new. You would not be creating a precedent, you would be applying the established case law of this court as it has come up in every case that reached the reparations phase. And in every case, the judges explain that they cannot recognize direct victims outside the framework of the crimes expressly recognized in the judgment itself. And I refer to references 22, 23, 24, 25, and 26. As explained in Ntaganda, the ICC is a court of last resort bound by the principle of complementarity. It cannot assume responsibility for repairing the harm of all victims of all crimes. That's reference 27. And with due respect to the Victims' Council, the strategic choices of the prosecution do dictate the scope of ICC cases. And reparations is not the forum for rewriting the Rome Statute. And the role of the ICC as a court of last resort and a court which is not a human rights court writ large. Surveys cannot replace a sound evidential framework tied to convictions. We fully support the right of such individuals to be assisted by the Trust Fund's other assistance mandate. We fully support their right to participate in collective reparation schemes and for the specific experiences of collective suffering to be acknowledged and prioritized in such schemes. And my colleague Maître Berrieux-Lussier will address that. And while we take no position on the definition of indirect victims, we note that this concept could capture the multifaceted forms of collective harm that existed in 2012. For those who stayed, those who fled, those who saw exactions on the street, and those who hid inside. Videos of punishments were circulated widely in Timbuktu and also refugee camps. And to limit this notion to those who witnessed the crimes in person would result in an arbitrary distinction between those who remained in Timbuktu and could freely circulate and those who could not. And we ask in turn that the Chamber pays special attention to the way it words its reparation order, and the way it is framed, so as to ensure that the public appearance and the public understanding of Mr. Alassane's responsibility is consistent with the limits set out in the trial judgment. Thank you. I will now turn to my colleague, Maître Berrieux-Lussier.
Good morning. Bonjour, Madame la Présidente. J'en ai pour environ 15 minutes à m'adresser à la Chambre, le temps qui reste à la défense. Est-ce que vous souhaitez qu'on reprenne, qu'on poursuive ou qu'on reprenne après la pause? Je suis à votre disposition.
I think that it's probably easier than if we take the break at this point, and then you can commence with your full 15 minutes, so as to not interrupt you in an awkward point in your submissions. And we can return and deal with the remaining submissions after the break. So we will recommence at 2:40, which would adhere to the hour-and-a-half break that is forecasted. I believe my calculations are right, unless someone corrects me on my math. Okay, thank you very much. We are adjourned until 2:40.
All rise, veuillez vous lever.